Florida has seen a lot. We've seen hurricanes tear through neighborhoods. We've seen headlines that feel unreal. We've seen chaos become normal. But nothing destroys a family faster than this. When legal power is triggered at the exact moment someone becomes vulnerable and everyone involved truly believes they are protecting them. That's when things get dangerous. And today's story became one of the most infamous legal battles in Florida history. Not because of money and not because of greed and not because anyone was trying to be cruel. It happened because nothing was written down. And you really can't make this stuff up. I'm attorney Otto, a Florida estate planning and asset protection attorney. And today I want to walk you through the Terri Schiavo case. Not as politics, not as ideology, but as what it really was. A failure of incapacity planning with devastating consequences. Now, Terri Schiavo was a young woman living in Florida when she suffered a catastrophic medical event that left her in a persistent vegetative state. She was alive, but she could not speak. She could not communicate. She could not make decisions. She could not tell anyone what she wanted. And here is the most important fact in this story. Terri had no living will. She had no advance directive. She had no written instructions explaining her wishes. Nothing said that if this happens to me, this is what I want. Nothing said, this is who I trust to speak for me. So when Terri couldn't speak, the law stepped in. In Florida, when an adult becomes incapacitated and there is no clear written plan, the court has to get involved. Someone has to be given legal authority to make decisions. Medical providers need direction, bills need to be paid, care decisions need to be made. The authority came through the guardianship process. Terri's husband, Michael Schiavo, became her legal guardian. And this is where a lot of people misunderstand what went wrong. A guardian is not supposed to act based on personal preference. Under Florida law, a guardian is a fiduciary. That means they are required to act in the ward's best interest and as much as possible in accordance with what the ward would have wanted. That phrase, what she would have wanted, is where everything fell apart. Michael said Terri had expressed in conversations during their marriage that she would not want to be kept alive by artificial means if there was no meaningful chance of recovery. Terri's parents, Robert and Mary, did not believe that. They believed Terri would have wanted continued care. They believed more could be done, and they believed that treatment should continue. Now, imagine this from a human perspective. Two sides who loved her. Two sides who were grieving. Two sides convinced they were defending Terri. But Terri herself could not confirm or deny any of it. So the courtroom became the place where her life was debated. What followed was not a simple disagreement. It was years of painful litigation, hearings, appeals, expert testimony, medical opinions, emergency motions, orders to remove treatment, orders to restore treatment. At times, Terri's feeding tube was removed, then reinserted, then removed again as the legal battle continued. And this didn't stay private. Protesters gathered outside, media cameras camped out. Religious groups weighed in, political figures weighed in, Congress got involved, the governor got involved. Terri Schiavo became a symbol. And that's one of the most heartbreaking parts of this story, because she wasn't a symbol, she was a person. But when planning is missing, families don't just fight quietly, they fight publicly. And once the case enters the legal system, especially one like this, it takes on a life of its own. Eventually, the Florida legislature passed a law aimed directly at this case, giving the governor authority to intervene and override the court's decision. People call it Terri's Law. Think about that for a moment. A law passed for one person. At that point, this was no longer just a guardianship case. It became a constitutional battle, a separation of powers fight. A question of whether the government could step into an individual family dispute and change the outcome of judicial proceedings already decided. The Florida Supreme Court ultimately ruled that the law was unconstitutional, not because the situation wasn't emotional, not because the outcome was easy, but because the structure of the law matters. Courts decide cases. Legislatures pass general laws. Governors enforce laws. Those boundaries exist precisely because emotions run high in moments like this. But let me bring this back to the core issue, because the politics tend to drown out the real warning. The real warning is this: Terri's wishes were never written down. So the legal system had to reconstruct her wishes through testimony, through memory, through people recalling conversations from years earlier, conversations remembered differently, filtered through grief, fear, anger, and belief. Florida courts in these situations require a very high legal standard, clear and convincing evidence before life-prolonging treatment can be withdrawn when someone can't decide for themselves. That's a heavy burden. But even with that burden, the court was still forced to weigh words instead of documents. And that is a terrifying position to leave your family in, because testimony is messy. Memory is unreliable. People can sincerely believe different things about the same conversation. And when there is no written directive, the court has no choice but to decide whose testimony is more credible. This is the part I want you to really sit with. People assume my spouse will know what to do. Well, sometimes that's true, but sometimes they remember differently. Sometimes they change. Sometimes other family members don't trust them. Sometimes grief turns into suspicion. Sometimes love turns into litigation. I have seen this play out in real life in Florida courtrooms without cameras and without headlines. And that is exactly why this matters so deeply to me. This is why I chose estate planning as a practice area, because long before people are thinking about death, they are vulnerable to incapacity, to accidents, to illness, to moments where they cannot speak for themselves. And I've seen what happens to families when there is no clarity. I've seen siblings stop speaking, spouses accused of ulterior motives, parents and partners turned into opposing parties. I have seen families spend tens of thousands of dollars arguing over what someone would have wanted when that person could have settled it in a few sentences on paper. Planning does not remove grief, but it removes doubt. It removes chaos. It removes the need for strangers in black robes to decide the most personal questions of your life. Imagine how different this case would have been if Terri had signed a simple living will. One page, one clear statement. If I am in a persistent vegetative state with no reasonable chance of recovery, I do not want artificial life-prolonging procedures. Or the opposite, I want everything done to keep me alive. Either answer would have mattered. What matters is that it would have been hers. Imagine if she had appointed a healthcare surrogate and said, "This is the person I trust to carry out my wishes." Now, the evidence isn't testimony, it's a document. Now the court's role is minimal. The case stays private, the family grieves instead of litigates. That's what planning does. So if you're in this position, you may not be there yet, but if you think that maybe in the future you might want your family to have clarity, consider getting these documents in place. It can help to bring so much peace of mind to your family when they're in a difficult situation. And if this breakdown is helpful, if you want to understand how Florida law actually works before crisis hits, take a moment to subscribe. This channel exists to help Florida families avoid court, avoid conflict, and protect the people they love with clarity instead of assumptions. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.